Constitution Basics. An outline of the Constitution and how the voice to Parliament fits in. The Constitution is a legal document setting out the basic laws for the Government of Australia. Its power as the fundamental law of Australia relies on the Australian people's decision to approve and be bound by the terms of the Constitution. The Constitution was created on the assumption of the rule of law. As a result, it requires the government obey the law and provides checks and balances to ensure that occurs. The Constitution starts with a preamble that highlights the colonial origins of the Act, that is, where people of the separate and self-governing colonies, now called the states, agreed to join together to unite and become a new nation, the Commonwealth of Australia. It is deliberately structured into chapters to create a legal and political system that governs Australia. Rather than one central body holding all power, the Constitution has 8 chapters to spread power between the federal government and states, called the division of powers, and between the legislature, executive and judiciary, called the separation of powers. The role of the High Court is as a final court of appeal, and to interpret the Constitution. The High Court is a powerful check that ensures the legislature and executive act within their roles as defined by the Constitution. The Constitution is the people's document, so it can only be changed by the people. Therefore, the Constitution has a specific process to get the consent of the people before the Constitution can be changed, known as a referendum. The creators of the Constitution believed our rights were best protected by a parliamentary democracy. Therefore, it does not contain a Bill of Rights. It has been proposed that the Australian Constitution needs amending to recognise and respect the Aboriginal and Torres Strait Islander people, and to provide a permanent mechanism to listen to Indigenous peoples about matters that affect their lives so they can improve their outcomes and close the gap. The Voice proposal will not include a change to the preamble. Instead, the Voice will be a separate chapter in the Constitution, establishing a new body called the Voice. This new body will sit alongside other major institutions established by the Constitution such as the Parliament, Executive and Judiciary. The Voice will have the power to make representations to the Parliament and Executive Government of the Commonwealth on matters relating to Aboriginal and Torres Strait Islander peoples. Parliament will determine how the Voice will operate, including its composition, functions, powers and procedures. There are arguments on both sides of the debate for voting yes or no. The legal opinions in favour of the Voice proposal, the yes side, have said the amendment is a result of extensive consultation with Indigenous people who wish to be recognised in the Constitution as the first peoples of Australia, by having a voice that has a say on law and policies that affect them, treaty and truth-telling. Of these, only the Voice requires constitutional change. This amendment is said to be a modest change to the Constitution with a body that can only provide advice to Parliament and the government. The legal opinions against the Voice proposal, the no side, have said the amendment is significant, as it adds a new chapter into the Constitution that will divide Australians, giving Indigenous Australians a permanent and additional method of influencing public policy. The scope and impact of the Voice is uncertain, and the long-term impacts on our system of government are unknown. Voting is compulsory, and no one is forced to vote a particular way. It is up to each individual Australian to make an informed decision about whether they wish to make this permanent change to the Australian Constitution.